So, no, I wouldn't say I have a passion for HR.
Welcome back to Human Resources for the People. It's a human capital revolution. Today I wanted to talk about hostile work environment and what it qualifies for. It's important for people to really understand this because too frequently this phrase is thrown around without a firm understanding of what it entails and what's involved when it's done. And frankly, oftentimes it's hard to tell the line where someone has crossed. So most people think that hostile work environment just involves angry and aggressive behavior, but really, the United States labor law at this time doesn't really protect us from jerks on the federal level. I know that there are bullying statutes in specific states, but for example, on the federal level, the federal government doesn't really protect us from jerks. A hostile work involvement is really when it's illegal, hostile, or hostile behavior that must be targeted with employees with certain protected characteristics such as race, religion, or sex, and that includes sexual harassment. And as a result, coworkers who are just simply rude to everyone, regardless of their status, isn't breaking the law. It's not a hostile work environment as defined by the federal government. I think that that's a really important thing that, frankly, a lot of people miss and they don't get. It's that, hostile work environment is about protected class. It's not about jerks. But so you have to, the jerk behavior has to be done as a result of someone's protected class. In addition, the hostile work environment has to be so severe and pervasive that it stops or alters your ability to do your job. It must be objectively abusive. It can be anyone in the workplace, right? It doesn't have to be just a boss, but what the courts consider is how often the discriminatory conduct occurs, so how pervasive it is, whether or not whether or not the conduct was directed at you because of your protected status, what type of conduct was it, and would a reasonable person find the workplace hostile based on this conduct. And so there are a few signs of it. You can know that it's potentially a hostile work environment because you have repeated comments or jokes about a protected characteristic, displaying offensive symbols or pictures, threatening or intimidating behavior, physical assaults or unwanted touching, and of course, sexual harassment. If you're interested in learning more about this, they have some pretty awesome examples from The Office, which, as you can tell by my intro, I love, on the link down below from Jackson Spencer Law. So I wanted to use that as a springboard to talk about a recent court case in the Fifth Circuit that documented just this exact thing and what the courts look at when they look at these things. So in Gilbert or Edwin versus Clean Harbors, Gilbert Edwin asserted that he is an African American male who worked for Clean Harbors Environmental Services. He sued his former employer because of alleging racial discrimination, disparate treatment, a hostile work environment, and retaliation. And all of those allegations were denied. And so we'll talk real briefly about the history here. He started working in September of 2015. In 2017, he got hurt at work and left for 4 months. During that time, he filed for a workers' comp claim about 2 months later, 3 months later, and then about 4 months later, he filed a discrimination charge with the Equal Employment Opportunity Commission. And so he returned to work in January of 2018. So he returned to work like a month or less after filing an EEOC charge. Clean Harbors asked him to return to work and schedule a drug test per company policy. He let Clean Harbors know that he smoked marijuana and tested positive on January 16th, 2018, and 7 days later he was terminated for violating the alcohol and drug policy. He cited medical reasons as why he should be reemployed, although, of course, that does not work. Of course, marijuana is federally illegal, and so for the most part, unless there's a state statute that overrides, he's out of luck. Clean Harbors maintained the termination, and so then he just went against Clean Harbors with a hostile work environment, disparate treatment claim, retaliation claim under Title VII, a state law retaliation claim, as well as another state law retaliation claim. So we'll kind of look at these real quick and kind of consider these. With the hostile work environment, as we talked about before, he has to belong to a protected group. be subjected to unwelcome harassment, and this harassment in this situation was based on race, and that it affected the term or condition of his employment, and that the employer should have known that there was harassment and that they didn't actually try to fix it. And so, what ultimately happened is that apparently there were 6 acts of racial harassment that Gilbert Edwin suffered. However, the first 5 happened between September 2015 and November 2016. And as a result, the complaint was late, and the Equal Employment Opportunity Commission, refused to hear them. So, a lesson learned is that if you are suffering this sort of abuse or harassment, you should inform the Equal Employment Opportunity Commission as quickly as you possibly can, because there is time limits. And I believe it's a year, if I recall correctly. Please refer to the EEOC website if you're interested in filing, but I believe that's true. So the only thing that Edwin actually had was a low performance review by his manager. And so this is the only available hostile work environment claim that he could use, because everything else was untimely. And when Gilbert Edwin talked about the review, he didn't discuss it as particularly racially motivated in his deposition, or with the EEOC. He asked why he got poor reviews, why the manager, Bienvenu, gave him poor reviews, and he never mentioned race. He said that he's not a fair supervisor. And so, that it wasn't this behavior, poor performance review, wasn't objectively offensive. It wasn't very frequent. It wasn't severe. And it wasn't physically threatening or humiliating. And, it didn't ultimately interfere with the work performance. And so this claim was rejected. In addition, the disparate treatment claim, that is, effectively, in summarizing here, the idea that you need to look at whether or not people were treated the same, similarly situated employees. He said that he was similarly situated with Bryce Manuel because they shared the same job title. But ultimately, the EEOC and the district court found that they weren't similarly situated. They were a different job, and Manuel was hired to act as a lead press operator, and as a result, he was promoted. And since there wasn't anyone to compare to, he failed his claim in this regard. And that's pretty unfortunate. I mean, there are a lot of positions out there that are one-off positions, but there was no way to make the claim of disparate treatment under them. In addition, with the retaliation claim under Title VII, they had to look at, so at this point he filed the EEOC charge, and so he is alleging effectively that because he filed the EEOC charge that he was terminated. However, because Clean Harbors does have a policy of terminating for failing a drug test, and a policy for requiring a drug test after returning, there was no evidence of retaliation. They were simply acting on their policies, and he was reacting to them. Right? He acted in concert with the policies. And as a result, he was terminated, and the 4th District affirmed the district court's grant of summary judgment of the claim. But that's a quick breakdown of what happened in a claim, how that works, and what hostile work environment is. It's often misused. It's probably as frequently misused as right to work versus at will, which I'll probably do a video because I've seen that happen so frequently. But I think that it's important for people to understand this. Let me know what you think in the comments down below. Like, share, and subscribe, and we'll see you on the next video. Bye, guys.